place.
Okay, there are charges against that are public documents. They are just going to ask you to respond to those charges.
If I respond to it as if I'm the one that is going to stand
You
by
can
it.
say it's a lie.
No, I cannot afford to say anything unless otherwise when my counsel appear. He's
So
the one
now it means that you want to wait
until my counsel.
Did you call your counsel?
Yeah, he's coming. He's coming.
Please, we are very sorry.
Let him come. Yes.
Alaye waka fast now. Today, the EFCC wanted to arraign my client, Elijah Bakr Andere, but after reading the charges, we objected to the taking of the plea. Why? Because the charges were brought under a non-existing law. Well, the counsel to the claimant, or rather complainant, sought for written addresses from both sides before the court gave it its stand or ruling on the objection we raised. So then he was brought under Penal Code Law Cap 89 of 1963, which has been repealed in 2022 by the Zamfara State Government as it relates to Zamfara State. We have our new Penal Code Law.
So, how did you respond to the agreement of the council?
We maintain our standard. We cannot plead to a charge which has been brought before under non-existent law. They said they have authorities to address the court on why the matter should proceed. We're waiting for them to see the authorities.
So, client granted bail, and what are the conditions?
Yes, we moved the court to allow him to proceed with the administrative bail earlier granted to him by EFCC. They admitted yes, he was under bail. So based on the same, the court extends the bail, but under different conditions. The conditions are that he has to produce 2 sureties in the sum of 5 million naira. Not that they should deposit, in the sum of 5 million naira. And the sureties should deposit their passport photograph with the registry of the court. So,
Okay, he was brought to court today on 2 counts of charge. First count bordering on criminal breach of trust, and another count bordering on forgery. Proceedings in court today required that, as the court ordered, that both counsels address the court formally on the issue of jurisdiction. The court that we have come before today is a court of record, a superior court of record, that requires that anything that you are bringing before the court should be done formally. For this reason, the court has ordered that we come formally and address the court on jurisdiction and the counts before on which the defendant is being to be arraigned. Yes. So, like I said, this is the court of superior record. The court has ordered that we address on the issue of jurisdiction. These are matters of before the court to decide. I would like to comment, but the court is going to ultimately decide. We have our arsenal, in our arsenal, our legal guns to bring to court, which we will do so accordingly as the court has ordered. It is not proper in law to now start telling you this is that or that is this. The court will decide one way or the other. But I can assure you that the law is right, and this is the law that we are bringing before the Honorable Court.
The accused has been granted bail. What is your explanation?
Fundamentally, bail is at court discretion, but the pronouncement of the court, as you must have heard, is the defendant is granted bail with the condition of 5 million naira, two shorties in like sum, both shorties to be resident within Gusau, and these shorties to be to deposit their passports with the registry of the Honorable Court. The court also added that the inability of the defendant to meet up with these conditions, the defendant is to be remanded in prison custody. This is the pronouncement of the court, and this also made pursuant to the discretion of the court to grant him. And that is how it transpired. Yes.